Good evening to everyone. On behalf of CNICA and our event associate, the Federation of Telangana Chambers of Commerce and Industry, I am privileged to welcome all the participants for today's study series. You have been a constant source of support and motivation for CNICA to conduct the study series. Historically, the approach to arbitration and its jurisprudential development in India have been reactive and scattergun rather than proactive and structured. For any essential arbitral system, there are three essential ingredients. One, the competent and experienced legal personnel. Two, the world-class faculties and utilities. Three, a supportive institutional and formal judicial system. The availability of an efficient support service such as transcription, translation, conference facilities, and trained operator are other vital ingredients. A common thread that runs through the jurisdiction of an international arbitration hub is: one, a stable, well-settled, and consistent approach by the local court system. Two, discouraging frivolous challenges to award and consistency of judicial approach to arbitration issues brought before courts across the country. Courts particularly need to take a pragmatic approach towards minimum intervention and maximum execution, which will respect the arbitral process and honor arbitral awards. In Singapore, the legislature has been doing quick to undo any conflicting or anti-arbitration decision within months, sending out its pro-arbitration message loud and clear. This brings in certainty, predictability, and stability, which is the essential bedrock for a hub. It has been quite often that foreign companies entering into business contracts with Indian companies prefer a foreign arbitration center for dispute resolution, primarily due to lack of institutionalized arbitration in India. Most Indian arbitration centers are now seated in Singapore. SIAC's report for 2015 shows India as the largest non-Singaporean contributor to its caseload. It is fundamental that the trio, judiciary, legislature, and the government, create the right turf and on-field conducive condition, vibrant and commercial ecosystem and environment which facilitates ease of doing business for achieving its dream of becoming an arbitration hub. The legal framework surrounding arbitration in India has witnessed a paradigm shift in recent years. The legislature has amended the Arbitration Act in 2015 and set timelines to increase the pace of arbitration and make it more time-bound, result-oriented, and disciplined. It must be emphasized that many of the retrograde judgments, which sometimes led to stalling of arbitration and encouraging reluctant parties to adopt guerrilla tactics, now stand largely neutralized by the 2015 amendment to the Arbitration Act. And it would be fair to expect that the arbitration in India would normally be in as friendly and supportive environment as anywhere else in the world. The passing of Arbitration and Conciliation Bill 2019 on 1st August 2019, and that of the New Delhi International Arbitration Center Bill 2019, are the first few firm steps in the long walk ahead of us in terms of making India an international arbitration hub. Several of the provisions of the Arbitration Amendment Act 2019 are welcome in their attempt to narrow the scope of challenges, rationalize the perhaps unrealistic time frame for disposing the arbitration proceeding, making it more difficult to avoid arbitration, and enhancing the arbitral tribunal power to pass interim orders. International arbitration centers do not appear overnight. The process is a long one and requires a steady long-term plan for development on various fronts. However, India requires gigantic measures to emerge as a hub. We have with us today an illustrious and astute person in Professor Ajay Thomas, an international arbitrator and a director of a faculty of law at Manavaracham University, to address us on the topic, India as a hub for international arbitration. A person with admirable perspicacity in arbitration, possessing mighty intellect and great industry. May I request a chairperson to introduce today's speaker? Saravanan, over to you.
Thank you, Ashok, and thank you, Mr. Anand, for your introductory and welcome note. Friends, good evening and my warm greetings to one and all. Today's resource professional on the topic India as a hub for international arbitrations. Is it an idea whose time has come? Is Professor Ajay Thomas. Professor Ajay Thomas is an independent arbitrator and is also the director of the Faculty of Law at Manoratna University. Ajay has graduated in law from the University of Goa and pursued his master's degree from the National University of Singapore, specializing in arbitration and maritime laws. On being admitted to the bar, he practiced mainly on the original side of the Bombay High Court as junior counsel at the chambers of senior advocate Mr. S. Venkateswaran, who was widely regarded as the legend of shipping law in India. Ajay has had the unique privilege of working with three of the world's leading arbitration institutions and has over 17 years of experience as arbitration administrator, arbitrator, and advocate. From 2009 to 2016, he was director and founding registrar with the Indian subsidiary of the London Court of International Arbitration and also a member of the LCIA India Board of Directors. Prior to joining the LCIA, Ajay was counsel with the Singapore International Arbitration Center. He also served as assistant counsel with the Singapore Chamber of Maritime Arbitration. He is a member of the ICC Commission on Arbitration and ADR, and he is a national correspondent for India to UNCITRAL's cloud system. Ajay is on the panel of arbitrators of SCOPE, the apex body of Indian public sector enterprises, and until recently was the vice chairman of the ICC Court of Arbitration's Indian Arbitration Group. Ajay was also a part of the expert committee that assisted the Law Commission of India in the preparation of its report on amendments to the Arbitration and Conciliation Act 1996. Ajay is a visiting faculty at the Indian Society of International Law, New Delhi, where he teaches arbitration. Ajay is also a guest faculty at various other universities and has been a speaker, resource person at arbitration training courses conducted by the Indian branch of the Chartered Institute of Arbitrators. Ajay is on the international editorial board of Brazilian Journal of Alternative Dispute Resolution and until 2019 was Hong Kong's 45th regional ambassador for India. With this short introductory note, on behalf of CNICA, FTCCI and the participants, I once again welcome Professor Ajay Thomas and request Professor Ajay Thomas to deliver his presentation. Thank you.
Thank you, Saravanan, for that very elaborate introduction, if I may say. That was anything but brief, Saravanan, and you were being most kind. So, ladies and gentlemen, a very good afternoon to all of you. And at the very outset, I would like to thank CNICA, and especially the three Murtis who run CNICA, Saravanan, Anand, and Ashokapati, for your kind invitation. And I must not forget the Federation of Telangana Chambers of Commerce and Industry also for their joint invitation and for being the joint organizers of this exciting webinar. I'm grateful to all of you for having given me this opportunity to speak on a topic which is very close to my heart. And given the recent positive developments in the Indian arbitration ecosystem, I believe it's a topic which deserves some analysis. Now, there's one point I need to emphasize at the very beginning. Friends and acquaintances who know me have a tendency to call me as Ajay PowerPoint Thomas, PPT Thomas, Ajay PPT Thomas. So, ladies and gentlemen, true to my middle name, my speech for today will have PowerPoints. So please allow me to share my PowerPoint presentation, which will form the basis of my interaction with you today. Okay. So ladies and gentlemen, gentlemen, what you see on your screen is my topic for today. India, which is that colorful mosaic of different races, cultures, religion. What I'm going to do today is try to analyze and see as to whether this country that we call India, this jurisdiction that is India, whether India can be an arbitration hub. Is the idea of India as an arbitration hub come? Is it an idea whose time has come? So that's going to be the focus of my presentation. So, ladies and gentlemen, it is undeniable that the past few decades have seen a gradual but perceivable shift in the choice of dispute resolution methods, especially for commercial disputes. And arbitration today is increasingly being looked upon as a viable alternative to litigating in a court of law. Now, this viable alternative that is arbitration is not only an international trend, which you see from studies which have been conducted internationally, where there is a marked preference amongst multinational corporations to resolve their disputes through the medium of arbitration. But this trend of using arbitration to resolve commercial disputes is not restricted only to the international arena. It is also reflected in the choices which parties make in India. Let me share with you the brief results of two studies conducted by EY and PwC. Now, the study by EY in 2011 was called Emerging Trends in Arbitration in India. And this study, ladies and gentlemen, showed that 74% of contracts had an arbitration clause. Now, moving forward, 2013, there was a study conducted by PricewaterhouseCoopers called Corporate Attitudes and Practices Towards Arbitration in India. Now, this study showed that 91% of companies surveyed preferred arbitration and not litigation for the resolution of their future disputes. So, ladies and gentlemen, what you see here is that there has been a marked preference for corporates to be moving from traditional litigation before a court of law to arbitration to resolve their disputes. And this has been a marked trend over the last decade or so. How popular is arbitration in India? Is it a first choice? Well, let me share with you on your screen a valet parking coupon of one of New Delhi's best Bengali cuisine restaurants. Now, this restaurant is called O Calcutta. Now, if you see the valet parking coupon conditions, the last paragraph says, all disputes shall be finally settled in India through arbitration conducted by a sole arbitrator duly appointed in accordance with the Indian Arbitration and Conciliation Act. So, ladies and gentlemen, the short point I'm trying to make here is that arbitration in India today is not restricted to only high value, complex commercial contracts, but you find the choice of arbitration for resolving disputes also in mundane day-to-day contracting situations. So that, ladies and gentlemen, I think is reflective today of the popularity of this process of resolving disputes called arbitration. And to a large extent, this popularity, notwithstanding the real advantages of arbitration vis-a-vis litigation, the large reason why arbitration has become so popular is because the mainstream public justice system in India, represented by the courts, is saddled with this huge tendency of cases. At the last count, ladies and gentlemen, there were about 34 million cases, 34 million or 3.4 crore cases pending in the various courts in India. And therefore, ladies and gentlemen, the public justice system represented by the courts have often been compared to the Jeep that you see on your screen. Just like the Jeep on your screen, the public justice system in India is said to be overburdened, overcrowded, and as a result of which its wheels of justice move ever so slowly. So this is perhaps the reason why the grand old man of arbitration in India, Fali Nariman, in a speech delivered at an IBI conference in 2015, Fali said, and I quote the grand old man, "The future of arbitration is bright, perhaps because the future of litigation is not." So, ladies and gentlemen, what has happened is that arbitration has undeniably come to be the most popular form of arbitration. And this popularity of arbitration as a process has had the great effect of awakening all stakeholders and guardians of the process in India to the tremendous potential that arbitration offers, not only as a plausible solution to resolving the huge judicial backlog conundrum, but also in providing a mechanism for facilitating the ease of doing business in this country. And ladies and gentlemen, in this process, the judiciary has been a vanguard by its actions, which have resulted in the establishment of numerous court-annexed arbitration centers. The first court-annexed arbitration center was established way back in 2009 by the Delhi High Court. It was initially called the Delhi High Court Arbitration Center, but today it has been renamed as the Delhi International Arbitration Center. So you find the courts have themselves come around to promoting the virtues of arbitration. And the government, ladies and gentlemen, has also recognized the importance which an effective arbitration mechanism can play in attracting foreign direct investment into the country. And this has resulted in the government according a national priority to the creation of an enabling alternative dispute resolution ecosystem. And this, to a large extent, as you see on your screen, has been done with a view to seeing the fruition of the stated vision of the government to establish and promote India as an international arbitration hub. And the evidence, ladies and gentlemen, of this prioritization of the government can be seen in the 2015 amendments to the Arbitration Act and also in the 2019 amendments to the Arbitration Act. It is also reflected in the Department of Justice's action plan to reduce government litigation. We must remember that the largest litigator or use of dispute resolution services in India is the government. And the Department of Justice's action plan to reduce government litigation endeavors to be referring increasing number of these disputes to arbitration and other forms of ADR, because the government itself has realized that litigation, there is no future in trying to resolve all kinds of disputes through the courts because of this huge backlog of cases. So, ladies and gentlemen, in light of these recent developments on the judicial front, as well as on when you look at the recent initiatives of the government, it could be argued that the time is indeed ripe for an objective consideration and analysis of whether India has indeed the potential to be an arbitration hub. So when you're looking and analyzing this issue as to whether India has the potential to be an arbitration hub, I believe the first issue that you need to look at is whether it is the right time for the country to be working towards establishing itself as an arbitration hub. So let me start off, ladies and gentlemen, with a bit of historical perspective. There was a time not too long ago, and I remember the time very clearly, about 20 years ago, when India was considered as a virtual outcast by many in the international arbitration community. And this, ladies and gentlemen, was to a large extent because of the many unfriendly court decisions that were emanating from our high courts and from the Supreme Court. And I can relate to this because at that point in time, I was working in Singapore with the Singapore International Arbitration Center. And that is a time when we had a lot of these very, very unfriendly court decisions which came from the Supreme Court of India. And I remember there was universal condemnation in international arbitration circles as to the credentials of India as an arbitration-friendly jurisdiction. The universal opinion was that India was a very unfriendly jurisdiction to be doing arbitrations. The universal opinion then was that to steer away from having a seat of arbitration or even a venue of arbitration in India, because there was a perception, not wholly unjustified, that the courts in India tended to interfere a lot in the arbitration process. So when you're looking at these arbitration unfriendly decisions, ladies and gentlemen, the first blow came in 2002 with the decision called the Bhatia International versus Bulk Trading decision of the Supreme Court of India. Now this was followed with a disaster called ONGC versus Saw Pipes 2003, and then came the 7-judge bench of the Supreme Court in 2005, SBP versus Patel Engineering. And the last nail in the coffin, ladies and gentlemen, was Venture Global Engineering versus Satyam Computer Services of 2008. Ladies and gentlemen, these 4 decisions were subject to universal criticism for being against the very spirit that arbitration stood for. And these, ladies and gentlemen, I must emphasize, were the bad old days of arbitration in India. And from here, if we were to fast forward to today, fast forward to 2020, the question that begs to be answered is, has there been such a sea change that from being seen as an arbitration unfriendly jurisdiction, India today is aspiring to be a hub for international arbitration? Has the country really moved on from those days when arbitration in India was described by Justice Desai of our Supreme Court in that landmark case, Guru Nanak Foundation versus Ratan Singh, where Justice Desai had described arbitration in India as making lawyers laugh and legal philosophers weep? Have we really moved on from those days, ladies and gentlemen? If you were to ask me, the answer is an emphatic yes. It is indisputable that the ground realities have changed in India for the better. But the question that we need to ask now is this, that have these changes been so transformative that India can today realistically aspire to be an arbitration hub? So that's the question. We are not on the issue as to whether ground realities have changed for the better or not. ground realities have indeed changed. But are those changes so transformative that it would be wise for the nation to be aspiring realistically to be an arbitration hub? That is the question that we need to look at in a very objective manner today. So if one were to go with statistics now, which have been emanating from leading arbitration institutions and the trends which have been reported by recent international surveys, it is but certain that the tide, ladies and gentlemen, of arbitration, and especially institutional arbitration, is rising. And safe in that age-old wisdom that a rising tide lifts all boats, with the exception perhaps of boats with holes in their hulls, I believe it is as good a time as ever for India today to be launching a strong arbitration ship and benefit from this rising tide of arbitration. Now, ladies and gentlemen, talking about this rising tide of arbitration, I'm reminded of a keynote address delivered by one of those great philosophers of modern international commercial arbitration, Mr. Sundaresh Menon. In his keynote address at the CNICA conference held in 2012 in Singapore, Mr. Sundaresh Menon, who was then the Attorney General of Singapore and today the Chief Justice of the Supreme Court of Singapore, in a speech said, and I quote Mr. Menon, "I venture to begin by suggesting that this new age of arbitration is in fact its golden age. Those amongst us who practice it are extraordinarily privileged to be able to do so at this time." So, ladies and gentlemen, it is undeniable that this is indeed the golden age of arbitrations. If you see the popularity of arbitration, not only in India but internationally, there has been that marked shift towards resolving disputes through the medium of arbitration. It is also called the golden age of arbitration, ladies and gentlemen, for the sheer fact that the courts today, almost on a universal basis, have realized that arbitration is a parallel system of dispute resolution, and it is better to leave that parallel system to its own devices. So that, again, that realization which has dawned upon the international judiciary, ladies and gentlemen, is also one of the reasons why arbitration today, it is called the golden age of arbitration. So now moving on, I think I've established the fact that it is perhaps the right time for us to be actually looking at establishing and working towards India being an arbitration hub. But before we look at the relative strengths and advantages of India's to be an arbitration hub and to position itself as an arbitration hub, it would be very, very important to look at what are those basic ingredients which go to make a jurisdiction as an arbitration hub. What are those key characteristics, features that a jurisdiction ought to possess for it to be recognized as an arbitration hub? So the first ingredient, ladies and gentlemen, is a proactive government. It is very important to have a government which is knowledgeable, which is perceptive and supportive of arbitration. We must remember that the recent Singapore success story is a story that was entirely conceptualized and scripted and driven by the government. I recall from my years spent working at the Singapore International Arbitration Center that the government in Singapore was so focused on promoting arbitration and promoting Singapore as a hub for arbitration, that there was a reference to arbitration in almost every speech that a minister or a senior bureaucrat made notwithstanding that the occasion had nothing to do with arbitration or was not even remotely related to the law. That just goes to show the unwavering, dedicated focus on establishing that jurisdiction as an arbitration hub. So, a proactive government. I believe that's the first and basic ingredient when you're looking at a jurisdiction to be an arbitration hub. The second ingredient, ladies and gentlemen, I believe is an independent and supportive judiciary. Arbitration, we must remember, is not a freestanding system of justice. Arbitration doesn't function in a vacuum. It is a system which is established and regulated pursuant to a law. And therefore, notwithstanding that arbitration's roots lie in the principle of party autonomy, it is somewhat paradoxical that the national courts always remain the final guarantors of the legal fitness of the arbitration process and of the awards delivered and the decisions delivered through that process. A judiciary, ladies and gentlemen, after all, that needs to be a pro-arbitration. For a jurisdiction to be an arbitration hub, it is very important for a judiciary to follow a pro-arbitration minimal interference policy. After all, we must remember that an arbitration law, no matter how well drafted, is only as good as the court interpreting and enforcing that law. Please remember, ladies and gentlemen, that the judiciary, notwithstanding that arbitration is an alternative to the court system, or arbitration derives its support, derives its existence from the support that it gets from the court system. And if that court system is not going to be supporting the process, and if the court system is not going to be interpreting and enforcing the law as per the spirit of the arbitration legislation, you will not have a jurisdiction that can be considered as arbitration friendly. Moving on now, ladies and gentlemen, the third ingredient for an arbitration hub is a modern arbitration legislative framework. A well-drafted, modern, user-friendly legislation that is aligned with international best practice and revised periodically to provide explicit legislative support to contemporary innovations and techniques in arbitration is very, very, very important. Just look at the recent example of Hong Kong and Singapore. Hong Kong and Singapore recently amended its arbitration legislation to allow third-party funding in relation to international commercial arbitration. As you all know, there has been a recent trend towards third-party funding in international commercial arbitration. But there was a big question mark, legal question mark, as to whether the legal systems in those respective jurisdictions permitted parties to resort to third-party funding in international arbitration. And this, to a large extent, is because of certain common law principles relating to maintenance and champerty, which were existing in a lot of Commonwealth jurisdictions. Now, third-party funding in international arbitration is considered today to be an integral part of that entire arbitration ecosystem. And to promote and to permit, or rather to permit and to promote the concept of third-party funding in international arbitration, these two jurisdictions, these two Asian jurisdictions, Hong Kong and Singapore, the legislatures of these two jurisdictions very quickly moved an amendment to permit third-party funding in international arbitration. So it is no wonder, ladies and gentlemen, that Hong Kong and Singapore today continue to be the most popular arbitration hubs in Asia, and I would say also internationally. It is because of the modern arbitration legislative framework that these jurisdictions have. Now look at the Singapore International Arbitration Center, the Singapore International Arbitration Act. Ladies and gentlemen, we must remember that in Singapore they have a dual regime when it comes to arbitration. They have two statutes relating to arbitration. For domestic arbitrations, you have the Arbitration Act, or the AA, and for international arbitrations, you have the Singapore International Arbitration Act, the IAA. So now Singapore is undeniably the leading arbitration hub in Asia, but this support that the legislature has provided to the process of arbitration, International Arbitration Act in Singapore has seen 9 amendments since 1994, including 2 whole-scale revisions in 1995 and 2002. And all these revisions and amendments, ladies and gentlemen, were done with a view to ensuring that the Singaporean legislation remains responsive to the evolving needs of end users and the legal profession. So that's why, ladies and gentlemen, the support of the legislature in providing for modern arbitration legislative framework is extremely important when a jurisdiction aspires to be an arbitration hub. Now, the fourth ingredient, ladies and gentlemen, is institutional support. Very, 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 very important to have a structure or a web of arbitration institutions that support the process of arbitration. And if you were to look at all major arbitration hubs in the world, it is undeniable that each one of these arbitration hubs, ladies and gentlemen, has an efficient, strong, unifying, flagship national institution. Just look at all the hubs in the world today. Look at Paris. Singapore has the SIAC. London has the LCIA. New York has the AAA, ICDR. Hong Kong has the HKIAC. Kuala Lumpur has the Kuala Lumpur Regional Center for Arbitration, which is today called the Asian International Arbitration Center, the AIAC. So every jurisdiction which is today there as an established arbitration hub, ladies and gentlemen, has a strong unifying national arbitration institution. Ingredient number 5, geographical location and world-class infrastructure. A convenient geographical location, excellent air connectivity, modern infrastructure, and state-of-the-art hearing centers, ladies and gentlemen, with supporting services like real-time transcribing, translation services. All of these logistical issues also are very, very important when it comes to constituting an arbitration hub. Now, talking about geographical location, the only jurisdiction, I believe, which is today aspiring to be an arbitration hub, which is slightly geographically disadvantaged, is Sydney. Now, Sydney, Australia, in recent years, thanks to the efforts of people like Doug Jones, have been making a great effort in trying to position Sydney and Australia as a hub for international arbitration. Now, this, ladies and gentlemen, is an exception to the rule, because if you look at Sydney and Australia, it's a land down under. It is geographically extremely disadvantageous. But notwithstanding that, you do have Sydney aspiring today also to be an arbitration hub. Ingredient number 6, ladies and gentlemen, a cosmopolitan legal fraternity. Every jurisdiction globally which would want to project itself as an international arbitration hub would have to allow freedom of choice of counsel and arbitrators. Now, there are certain jurisdictions which have tended to rely very heavily on foreign legal talent to quickly build up their reputations in the international arbitration hubs. However, this approach of relying on foreign talent has its own pitfalls. So the true test of a good arbitration hub would be for that jurisdiction to have its own core group of experienced arbitration practitioners. And when I say arbitration practitioners, I mean counsel as well as arbitrators. Ingredient number 7, specialist arbitration lawyers. Now, any jurisdiction again which realistically wants to be an arbitration hub would and should have a cadre of specialist arbitration lawyers. It is very, very important to have a pool of excellent locally based lawyers who would then in turn serve as potential local based arbitrators. And beyond specialist arbitration lawyers, support from the national bar councils and bar associations would also be extremely important. Hong Kong is a classic example of a jurisdiction where the local bar, the bar associations and the bar council in Hong Kong played a very, very important role in the promotion and development of Hong Kong as a hub for international arbitrations. So in that way, when you compare Hong Kong and Singapore, Hong Kong's growth story to a large extent has been the great work which has been done by the bar in conjunction with the government. Whereas in my view, if you look at Singapore on the other hand, the Singapore growth story and success story in arbitration to a very large extent has been scripted and driven entirely by the Singapore government. So therein lies a slight difference in the growth stories of Hong Kong and Singapore as arbitration hubs. So ladies and gentlemen, as India now looks at positioning itself as an arbitration hub, it would be very, very important for us to look. When I say look, I would say it would be very important for us to take a very deep look into the competitive advantages of India. And then having looked at the competitive advantages of India, in light of the recent pro-arbitration initiatives taken by the government and the judiciary, we will then have to analyze and see where does India stand vis-a-vis these fundamental ingredients which are necessary to establish an arbitration hub. So let's now look at the strengths of India. What are those strengths of when it comes to establishing India as an arbitration hub? What are those virtues which India has, which perhaps would go a long way in establishing India's credentials as an arbitration hub? The first, I would say, ladies and gentlemen, is the strong and growing economy. Well, yes, the growth story is affected thanks to COVID-19, but I think that is a global story. But if you were to see the scenario which was pre-COVID-19, it is undeniable that the last 2 decades have seen a steady transformation of the Indian economy from what was called a large plodding elephant into a sprightly tiger. Ladies and gentlemen, India today is the world's sixth largest economy by nominal GDP and the third largest, if you were to look at it, by the purchasing power parity method. The 2019 Global Economic Prospect Report released by the World Bank projects India's GDP to grow by 7.5% in 2020 and to stay at this pace over the next 2 fiscal years. But again, COVID-19 has affected these figures. But beyond the growth story, what is very important from an Indian perspective is that the Indian economy's growth story has to a large extent been fueled by this large middle class that we have in India, a middle class that is almost 250 million strong, ladies and gentlemen. It is this middle class of 250 million people who will continue to drive India's consumer spending and fuel its robust economic growth. So when you compare India's growth story, say, to China, which to a large extent has been fueled by exports, India's growth story on the economic front has been internal consumption. So, in a way, I believe, notwithstanding COVID-19, in the new world that emerges post COVID-19, I think there will be a renewed emphasis on growth in India, thanks to this huge internal consumption. Now, what is also very, very important, ladies and gentlemen, that given these 2 decades of transformative growth, what is very, very interesting from an Indian's perspective is that international perspectives towards India as a jurisdiction have changed. And this is very, very, very important. The perception that the international community has towards India as a jurisdiction, as an economy, has changed over the years. 2 decades ago, there was a general disinterest which was there with anything relating to India. But today, I'm very happy to note that the general disinterest has given way to quiet admiration and respect. And ladies and gentlemen, as the economy grows, the demand for dispute resolution and legal services, in my view, will also see a corresponding proportional rise. And given the undeniable strengths of the Indian economy and its emphasis on internal consumption, international investors will continue to be focused on India. They will continue to be keen to do business in India. Having said that, whilst some of them might prefer to arbitrate in neutral seats outside of India, like, say, Singapore, and as Anand said in his inaugural remarks, Singapore continues to be a very popular jurisdiction for India-centric arbitrations. Well, that will continue to be there, but there will at the same time be a lot of international investors who will now be happy to have their arbitrations seated in India, and also not only seated in India, but also their venue in India. And you must remember that it was essentially this market of international investors investing and doing business in India and through India, it was this market, it was this constituency that the London Court of International Arbitration had looked in tapping into when it had established its subsidiary in India in 2009. As you all know, that subsidiary, which was called LCIA India, established in 2009, wound up in 2016. But the very, very important fact about that institution, which existed for 7 years, which was called LCIA India, is that it was perhaps the first example of Make in India in the arbitration sector. Of course, Make in India as a concept came into being only later on, but 2009, ladies and gentlemen, the LCIA's establishment of LCIA India, I believe, was the first example of Make in India in the arbitration sector. Now, so that's one of the strengths of India, and the strong and growing economy was one of the primary reasons, ladies and gentlemen, why a leading international arbitration center like the London Court of International Arbitration had established its first independent subsidiary outside of London in India. And that will continue to be one of India's great strengths. Second, I would say, ladies and gentlemen, we do have a modern legislative framework in India. Now, the legislative framework that supports arbitration in India is, as you all know, the Arbitration and Conciliation Act of 1996, which is based on the UNCITRAL model law, which again is considered by most international jurists to be the gold standard when it comes for arbitrations. And further, this gold standard of 2015 has undergone significant reform since 2015, which has resulted in injecting a great deal of discipline into the process without compromising on party autonomy. For example, now the Indian arbitration legislation also empowers the courts to grant interim orders in aid of international arbitration, which was not possible prior to 2015. Now, regardless of whether the arbitration is seated in India or not, the courts in India now today have the ability to grant interim orders in support of international arbitrations, so which I think shows the fact that the legislation in India has moved with the times. India is also a signatory to the New York Convention, which enables awards from India to be enforced in 165 countries in the world. You must remember that India was one of the original signatories to the New York Convention. Jurisdictions such as Singapore, for example, signed up to the New York Convention only somewhere in the 1990s. Even the UK became a New York Convention country, I believe, somewhere in the 80s. So you must remember that there was a time when India was at the forefront of international commercial arbitration. It was one of the founding fathers of the New York Convention. Okay, now moving on to the other strengths of India, I think it can be safely said that there is no anti-foreigner bias in the Indian public justice system. This is very important. If for any jurisdiction to aspire to be an international arbitration hub, that jurisdiction there should not be a perception that there is an anti-foreigner bias. Now, in support of this, I'd like to quote Fali Nariman in his brilliant speech titled 10 Steps to Salvage Arbitration in India, which was delivered at the first LCIA India annual arbitration lecture. And I quote Mr. Nariman. And Mr. Nariman, in his speech, has quoted a study conducted by Mr. Sumit Kachwaha, which was published in the Asian International Arbitration Journal, volume number 4, number 1, 2008. So quoting Mr. Sumit Kachwaha's article and the statistics, Fali Nariman remarked in a speech, and I quote Mr. Nariman, "The foreigner loses or wins. The foreigner loses or wins as often as the local. In fact, the statistics show that in the last 60 years, amongst the important and reported arbitration cases that ultimately reached the Supreme Court, both under the old law and the new law, foreign parties succeeded in 14 out of 22 cases. And as for Indian high courts, if you browse to the ICA yearbooks, which also report High Court decisions, you will find that the tally is that out of 17 important cases decided by the High Courts in India, cases which were not taken to the Supreme Court, foreign parties succeeded in more than half of them. So ladies and gentlemen, here you go. The grand old man of arbitration, quoting an empirical study conducted by Mr. Sumit Kachwaha, has very categorically proved that there is no anti-foreigner bias when it comes to decisions of the courts in India. Point number 4, rule of law. I would like to believe that the principle of rule of law has found a safe abode in the Indian Constitution. And further, given India's strong democratic ethos and our common law traditions, I don't think I would be wrong in saying that there is an understanding of, respect for, and application of the rule of law by a fiercely independent judiciary. Of course, the fierceness or ferocity of the judiciary probably has reduced in recent years, but nonetheless, I would like to believe that the Indian judiciary continues to be upholding the spirit of the rule of law and continues to be independent in all respects. Point number 5, legal expertise. Now, India has a legal profession of outstanding ability and reputation second to none. This is what I believe. The standard of legal training offered in India is well recognized by international law firms who over the past decade have been recruiting directly from leading Indian law schools. In a first, a gentleman I've known reasonably well, Dipin Sabharwal, a 2001 alumnus from a leading Indian law school, was recently made Queen's Counsel. Ladies and gentlemen, Queen's Counsel from somebody who graduated in 2001 from a leading Indian law school. I believe this is a remarkable achievement. And the fact that this is a remarkable achievement can be borne by the fact that there are more illustrious Indian senior counsel who have been appointed Queen's Counsel only very recently, post Dipin Sabharwal. So this just goes to show, ladies and gentlemen, that the standard of legal training that is offered by the best law schools in India is second to none. So talking about legal expertise, I think there's another welcome development. There has been a recent move to constitute a specialized arbitration bar comprising of lawyers whose practice is predominantly arbitration focused. For years, ladies and gentlemen, people in a lot of, people have always been talking about the fact that one of the biggest disadvantages of the Indian arbitration ecosystem is that there is no specialized arbitration bar. So that is why I say this is a new welcome development, that there is a body called the Indian Arbitration Forum, which is a first of its kind initiative which has been set up by leading Indian arbitration practitioners. And the whole idea of the Indian Arbitration Bar or the Indian Arbitration Forum, known by its acronym IAF, is to establish a dedicated group of professionals whose focus is only on practicing arbitration and not on litigation. So that's also a very, very welcome development on the legal expertise front. And ladies and gentlemen, last but not the least, I believe one of India's great strength is also the large and diverse diaspora that we have. There are common bonds of the people of a wide range of countries with India, from Suriname, Guyana, South Africa, to Mauritius, Singapore, Malaysia, and Fiji. Ladies and gentlemen, there is a large and diverse Indian diaspora which has to be tapped into. It is this constituency, along with that ubiquitous and influential non-resident Indian community, NRI community, which should be looked into, tapped into, to garner support in aid of India's arbitration ambitions. So, ladies and gentlemen, this is what I believe are the strengths of India when it looks at positioning itself as an arbitration hub. So, now if you're looking at the future, ladies and gentlemen, I must admit that there is no fortune teller. I am no fortune teller with a crystal ball to predict what the future of Indian arbitration will be. But there are certain recent initiatives of the two main sectoral players in India, that is the judiciary and the government, which does hold out the promise for a brighter future. Now, this very, very important and critical role of the judiciary and the government in promoting the development of arbitration has been beautifully described by a former Chief Justice of the DIFC courts in Dubai, who is also today a leading arbitration practitioner based out of Singapore. Ladies and gentlemen, the name is Michael Wang. Now, Michael Wang, in an article written in 2008 for the Asian International Arbitration Journal, wrote, and I quote Mr. Wang, "If arbitration can be likened to a football game, then the court and the government of the seat are the main referees and organizers of that football game. There is no use having the best players, the best rules, and the best gameplay if the referee does not recognize any of the goals scored, or the organizers do not provide a proper infrastructure or level playing field." Ladies and gentlemen, I think this quotation beautifully brings out the very, very important role that the government and the courts play in creating that effective arbitration ecosystem in a jurisdiction. So, on that note, ladies and gentlemen, let us quickly look at what has the judiciary been doing in India. What has been the recent initiatives with the judiciary? Now, something that we need to remember is that not only in India, but historically the world over, courts have viewed the process of arbitration with a bit of, I would say, a bit of suspicion, with a sprinkling of hostility. The judiciary over the years, again, not only restricted to India, but the world over, has had to find that right balance between supporting the process of arbitration and intervening in the process of arbitration. And I must frankly say, and truthfully, that in the past, there was some tension on this front in India. The tension between the courts being more interventionist rather than being more supportive. But ladies and gentlemen, in this connection, about 10 years ago, I had written an article for the GAR, the Global Arbitration Review, where I had said that as long as the attitude of the court in India towards arbitration remains an anxiety, a solution based purely on the amendment of the law is unlikely to work in India. So a solution to the Indian arbitration was based entirely on the amendment of the law is unlikely to work, because the judiciary plays a very, very important role, ladies and gentlemen. But over the last decade, I must say that a lot has changed with respect to the judiciary. There has been a very, very welcome course correction by the judiciary, and by and large, barring that odd, aberrant decision, most of the decisions that have been recently emanating from our high courts and the Supreme Court have been very, very supportive of the arbitration process. And I believe this is the correct approach when it comes to the courts vis-a-vis arbitration. There's also been a realization amongst the courts, ladies and gentlemen, that arbitration in conjunction with other forms of ADR can be an extremely useful tool in easing the pressure on the mainstream public justice system. And as you know, the public justice system in India is burdened with this huge backlog of 34 million cases. And this pragmatism and realism, or this pragmatic and realistic approach, which was alluded to also by Anand in his inaugural speech, has found a safe home in the judiciary's approach towards arbitration in recent years. It is also very, very commendable that the judiciary has itself taken upon the lead to institutionalize the process of arbitration in India, and this has resulted in the establishment of court-annexed arbitration centers in New Delhi, Bengaluru, Chandigarh, and also in Chennai. And if you go purely by statistics, these centers, in particular the Delhi International Arbitration Center annexed to the Delhi High Court, has achieved great success because it has administered in excess of 2,500 cases over the last decade or so. And that, ladies and gentlemen, is a very good statistic to keep in mind. Now, if you want to very quickly look at the initiatives of the government, so we have seen that we have looked at in my initial few slides at the government's resolve to create an enabling environment for arbitration to thrive in India, and keeping in mind its vision for India to be an arbitration hub. So in light of this vision statement of the government, it would be very, very helpful to very quickly look at what are those recent initiatives of the government on this front. Firstly, I would say liberalization of the legal services sector. Now on this front, ladies and gentlemen, we must remember that every jurisdiction wanting to project itself as an arbitration hub would have to allow the freedom for parties to choose their own lawyers. Now, consistent with the government's ongoing campaign to liberalize other sectors of the Indian economy, the government of India has also indicated its willingness to open up the legal services sector. In 2017, ladies and gentlemen, the Ministry of Commerce and Industry amended the Special Economic Zone rules. Rule 76 of the SEZ rules framed under the SEZ Act of 2015 were amended to revoke a ban on law and accountancy firms from advising clients from multi-services special economic zones. Whilst international law firms, ladies and gentlemen, will surely add to the depth of the existing legal talent in India, I honestly believe that the floodgates should not be open at one go. If at all, the legal services sector should be liberalized, it must be done in a gradual and phased manner, just in the way it was done in Singapore. Ladies and gentlemen, Singapore has been a shining example of an arbitration hub which has liberalized its legal services sector. But even in Singapore, that the floodgates were not open to foreign law firms and foreign lawyers at one go. There was a gradual opening up of the legal services sector in Singapore. And my opinion, that's my opinion, would be that this opening up of the legal services sector should happen, but it should happen in a gradual and phased manner. Second, ladies and gentlemen, initiative of the government. I talked about, there was an action plan of 2017 of the Department of Justice to reduce government litigation. This action plan suggests that all agreements between the government and private bodies should mandatorily include a reference to either arbitration or mediation. Thirdly, ladies and gentlemen, legislative stimulus. As I've alluded to earlier, a clear and unambiguous amendment of the law is one of the many ways in which you can actually undo the past aberrant decisions of the Supreme Court of India. Again, in this note, in this consideration, in this context, I'd like to quote Fali Nariman from one of his speeches. Ladies and gentlemen, as you would have realized by now, I've been an ardent admirer of Fali Nariman, not only because of his great writings, but also I've had the pleasure of being Mr. Nariman's neighbor for the last 10 odd years. So that is reflected, ladies and gentlemen, in many of my speeches and writings, that I've been very unashamedly been quoting Mr. Nariman. So Mr. Nariman in the 2011 speech said, salvaging arbitration in India is just not possible until at least 3 decisions of the Supreme Court are first put out of the way in our precedent. They are Bhatia International 2002, Saw Pipes 2003, and Global Venture 2008. These decisions have distorted the provisions of the 1996 Act, and the provisions as originally intended must be restored so that the Act is brought back to conformity with the letter and spirit of the model law, unquote. So, taking cue probably perhaps from this speech of Mr. Nariman, the government introduced the 2015 amendments to the Arbitration Act. The 2015, ladies and gentlemen, the amendments, ladies and gentlemen, not only did along with the Supreme Court's decision in Balco, not only did away with these 3 aberrant decisions of the Supreme Court, but also ushered in a new era for Indian arbitration by introducing a whole host of reformative provisions. I'm not going into detail into what those reformative provisions are. You all know it. Time limits for an arbitral award, disclosure norms influenced by the IBA guidelines and conflict of interest, public policy, that unruly horse of public policy to a large extent has been reined in, ladies and gentlemen, by virtue of an amendment to the definition of public policy. There has been a comprehensive cost regime which has been introduced, and the ghost of that automatic stay on enforcement has been laid to rest, ladies and gentlemen. So in this background of the 2015 amendments to the Arbitration Act and the whole lot of discipline which has been introduced, ladies and gentlemen, I cannot but remark that had these amendments been come just a few years before 2015, it perhaps could have forestalled the London Court of International Arbitration from taking its decision to shut down its Indian subsidiary in 2016. So, ladies and gentlemen, so I think these amendments came a little too late when it came from the perspective of that nascent institution called LCIA India, which shut down in 2016. I say that with a certain sense of sadness because I had the responsibility of establishing that institution in India, and I also had the misfortune of being the person who was responsible. I wouldn't say responsible. I had the misfortune of also winding down that institution in 2016, ladies and gentlemen. So that you will forgive me for having that perspective on the 2015 amendments. Now, ladies and gentlemen, beyond 2015, you also have the 2019 amendments to the Arbitration Act. And if I were to quickly look at the key legislative milestones, ladies and gentlemen, and how they have panned out in recent years, I would say that the initial stimulus for the legislative reforms came by the 246 report of the Law Commission of India. Now, ladies and gentlemen, may I ask the organizers as to how much more time do I have? Depending on how much more time Sarvanan is there, I can quickly wind up my presentation.
Oh, Sarvanan, please go. How long? You can. Will it take another 10 minutes?
I think not more than 10 minutes. Just about 10 minutes.
Yeah, complete it, Jay. No issues.
Yeah. Thank you so much, Sarvanan. So let's look at quickly at what has the government done in terms of the legislative stimulus. The stimulus came from the 246 report of the Law Commission of India, ladies and gentlemen. On the basis the report of the Justice A.P. Shah chaired Law Commission of India, the 2015 amendments to the Arbitration Act were introduced. 2015 Amendment Arbitration Act came into force. There were certain flaws which were recognized, and to correct those flaws and also to encourage the institutionalization of arbitration in India, ladies and gentlemen, the Government of India Ministry of Law and Justice constituted a high-level committee called the HLC, under the chairmanship of a retired Justice of the Supreme Court, B.N. Sri Krishna, to look at the 2015 amendments and also to look at the institutionalization of arbitration in India. Now, this report, this committee, this high-level committee comprising, very, very high-level committee, I should say, comprising of these distinguished people, gave its report in July 2017. And this report, a few of the recommendations of the high-level committee, ladies and gentlemen, beyond the amendment of the law, were to set up a body called the Arbitration Promotion Council of India for the purposes of grading arbitral institutions in India. It also recommended that the Arbitration Promotion Council of India recognize professional institutes for providing accreditation of arbitrators in India. And it also talked about incorporation of arbitral institutions in India as not-for-profit companies under Section 8 of the Companies Act and also under the Societies Registration Act. So, post the high-level committee's report, ladies and gentlemen, there was the 2018 Arbitration and Conciliation Amendment Bill, which was introduced in Parliament. The Law Minister described the bill as a momentous and important legislation aimed at making India a hub for domestic and international arbitration. This legislation was passed by the Lok Sabha, introduced in the Lok Sabha, but could not be taken up in the Rajya Sabha because of the adjournment of Parliament in 2019. And therefore, ladies and gentlemen, because that the bill could not be passed in 2018, it was taken up once again in 2019. And if you look at the legislative history of this 2019 Amendment Act, ladies and gentlemen, the bill was introduced in the upper house of Parliament in the Rajya Sabha on the 15th of July 2019. It got presidential assent, was passed by the Lok Sabha, passed by the Rajya Sabha, got presidential assent, and was published in the Gazette of India on 9th August 2019. So if you see, ladies and gentlemen, from the date of introduction in Parliament to publication and notification in the Gazette of India, it took just 22 days. And I think this is a takeaway. This is a big takeaway. I have always marveled at the speed with which the legislature in Singapore and in Hong Kong have amended the arbitration legislations in those respective jurisdictions. But ladies and gentlemen, here you have the hitherto very slow Indian legislature, the Indian Parliament, introducing a bill in Parliament and getting it passed and notified and bringing it into force all in the span of 22 days, ladies and gentlemen. So this gives me hope. This gives me a lot of hope that here is a government which can amend the law in a very quick span of time. Ultimately, the last important legislative reform, ladies and gentlemen, is also the introduction of a statute called the New Delhi International Arbitration Center Act. And this was introduced again in August 2019, ladies and gentlemen. And it relates to this beautiful structure in Delhi, which was called the ICADR. Now, the New Delhi International Arbitration Center, ladies and gentlemen, is a statute to take over this beautiful building situated in Delhi and to constitute the New Delhi International Arbitration Center as the flagship national arbitration center for India. The legislation also envisages the creation and establishment of the New Delhi International Arbitration Center as an institution of national importance. So this is important, ladies and gentlemen, because if you look at Singapore, if you look at Hong Kong, it is very important for any jurisdiction, if it has to aspire to be an arbitration hub, to have a strong and efficient national arbitration institution. a strong and efficient national arbitration institution can play a catalytic role in promoting the institutionalization of arbitration in India. Ladies and gentlemen, there is a perception, there is a myth that there are no arbitral institutions in India. But at last count, there were almost 45 arbitration institutions in India, ladies and gentlemen. So, but the problem with the institutionalization of arbitration in India, ladies and gentlemen, has been beautifully summed up by Mr. K.K. Venugopal, the current Attorney General of India, in a speech delivered in 2018, ironically at a conference organized by the Nani Palkiwala Arbitration Center. Mr. Venugopal said, and I quote Mr. Venugopal, "Unfortunately, India has no institution that can come anywhere near the efficiency and competency of international arbitral institutions," unquote. So, ladies and gentlemen, I honestly believe that here is an opportunity for all the existing arbitral institutions in India to quickly pull up their socks, to be more visible, to be more proactive, and to be setting up processes, to be setting up and recruiting people and setting up processes which can rival these international arbitration hubs. And ladies and gentlemen, apologies for being direct. I think this is where CNICA and the Trimurti who run CNICA, I think this is a big opportunity for CNICA to take advantage of this, of this pro-arbitration ecosystem which is trying to be generated by the government of India. Again, I'd like to quote Prime Minister Narendra Modi in a speech at that Niti Aayog conference held in 2016, where he said that the creation of a vibrant ecosystem for institutional arbitration is one of the foremost priorities of our government. So, ladies and gentlemen, it would be my unsolicited advice to all the arbitral institutions in India to take advantage of the ecosystem which has been created by the government to promote institutionalization of arbitration, and to ensure that the next time our learned Attorney General of India gives a speech, he can be proud of the fact that there will be domestic Indian arbitral institutions which can compete and compare with the efficiency and competency of international arbitral institutions. I think this, ladies and gentlemen, is a big, big opportunity for all Indian arbitral institutions. Look at the 2019 amendments to the Arbitration Act, ladies and gentlemen. I think the 2019 amendments to the Arbitration Act now will ensure that the process of appointment of arbitrators in ad hoc arbitrations under section level now will be divested to arbitral institutions. Of course, those relevant provisions have not been notified and gazetted because the Arbitration Promotion Council of India has not been constituted as yet. But it is only a matter of time before the Government of India notifies by gazette those provisions. And I think it is there, ladies and gentlemen, that all Indian arbitration institutions, including CNICA, will, take my word for it, the fortunes of all domestic arbitration institutions in India, ladies and gentlemen, are going to change. And therefore, I believe there is a big responsibility upon institutions like CNICA to, in this interim period, between now and between the gazetting and the notification of the 2019 amendment, those provisions relating to appointment of arbitrators, there is a big opportunity, ladies and gentlemen, for you to be establishing processes and creating an environment where the business community and the lawyering community has a confidence in the services that you repose. So that is, ladies and gentlemen, very, very important from an arbitration perspective. Now, let me quickly conclude by looking at defining goals. Ladies and gentlemen, you must remember that India played a pioneering role when it came to laying the foundations of arbitration as we know it today. India was only one of the 8 countries that was a member of UNCITRAL right from its very inception. And it was amongst the 10 original signatories to the New York Convention. India has also had the privilege of being the first Asian country to have played host to that prestigious biennial ICA Congress twice, in 1975 and then again in 2010. So ladies and gentlemen, for a variety of reasons, including our problematic arbitration legislation coupled with interminable judicial delays, the past few decades have been witness to India's inability to lead by example and to capitalize on the benefits of this pioneering efforts that India did to shape the modern law and practice of arbitration. Therefore, I believe, ladies and gentlemen, I strongly believe that the time has come for India to revisit its tryst with destiny and to work systematically towards redeeming its rightful position in the world of international commercial arbitration. However, when we are looking at defining goals, given the state of the existing legal and physical infrastructure and the priorities of an emerging economy, it would be very important for India to realistically define its end goal before it launches its arbitration ship. Ladies and gentlemen, the goal has to be realistic rather than merely rhetorical. So where does India see itself 5 years down the line in 2025 and then 10 years down the line in 2030? Once this question is answered, ladies and gentlemen, it would be very, very imperative to move to a phased plan of action by formulating a national arbitration policy. Very, very important, I believe. If you can have a new economic policy, why not have a national economic policy? Very important for policymakers in India to be defining and structuring a national economic policy. So, moving on, ladies and gentlemen, I must say that we've had a long history. Short point I'm trying to make with all these slides is that we've had a very long history of arbitration in India, which can be dated back to our ancient epics, to our ancient law digest, the Yajnavalkya Smriti, to the Panchayat system, which is nothing but a simplified form of arbitration. And if you see the codification of statutes in India, ladies and gentlemen, right from 1772, we've had a structured codification of laws relating to arbitration. So we must remember and be proud of this legal heritage, ladies and gentlemen. And ultimately, ladies and gentlemen, what is very, very important is when we're looking at positioning ourselves as an arbitration hub, we must remember that to be an arbitration hub over the past decade or so has been the aspirational impulse of many nations. Jurisdictions cutting across the economic, legal, and political spectrum, right from the Bahamas, Scotland, Nigeria, Rwanda, Mauritius, to Dubai, Saudi Arabia, Djibouti, Sydney, Kuala Lumpur, and Seoul, South Korea, ladies and gentlemen, have all declared their intentions to be arbitration hubs. So we are not alone in this aspiration to be an arbitration hub. So we need to remember that. And we must also remember that arbitration is a buyer's market in terms of choice of seat and venue. And this race to be an international arbitration hub, ladies and gentlemen, is intense. And I can confidently tell you that winning market share for a seat or an institution is never easy, ladies and gentlemen. It takes a lot of planning. It takes a lot of hard work, persistence, and patience, and also, very importantly, deep pockets. But be that as it may, if you were to go by the annual reports of leading international arbitral institutions, as alluded to by Anand in his inaugural speech, Indian parties have been, not surprisingly, contributing to a very large bulk of those arbitrations seated outside of India. Ultimately, ladies and gentlemen, what should India do when it comes to positioning itself as an arbitration hub? I would like to quote the sage advice given by Jack Welch, the former chairman and CEO of General Electric. Jack Welch used to often say, control your destiny or someone else will. So paraphrasing Jack Welch, ladies and gentlemen, I believe that the time has indeed come for India to take control of its arbitration destiny. After all, we have a government which appears to be serious about arbitration reform. The judiciary appears to be consciously making an attempt to be arbitration friendly. And if you look at the tremendous enthusiasm amongst the members of the bar and academia, and also the existing arbitral institutions and the chambers of commerce, reflected by the hosting of today's webinar by CNICA and the Telangana Chambers of Commerce and Industry, I can definitely see, ladies and gentlemen, an enabling environment for India to emerge as an arbitration hub. Let me conclude, ladies and gentlemen, this long-winded speech of mine by saying that it is highly unlikely that India will become an arbitration hub overnight. It is highly unlikely that India will become an arbitration hub overnight. And for this, all one has to look at is the recent example of Singapore. Singapore, ladies and gentlemen, started off way back in the early 1990s, and it has achieved a recognition as an international hub for arbitration only in the very recent past. If the end goal for India is to be an international arbitration hub, I believe the first step would be for India to improve its domestic arbitration scene, whilst concurrently positioning India as a regional hub, say for South Asian disputes, or for disputes emerging from a particular domain, such as information technology, in which India has a big competitive advantage. So, ladies and gentlemen, very, very important for India to find a niche. It just cannot be another hub. It simply will not work. Ultimately, it has been said, ladies and gentlemen, that there has been many a slip between the devout wish and its ultimate fulfillment. Having studied, lived and worked in Singapore for a few years, I've had the great privilege of seeing firsthand how Singapore has managed to transform its legal sector and emerge as a global dispute resolution hub. And therefore, ladies and gentlemen, I believe that it would require Herculean effort, resolute determination, backed by strong political will to turn into a living reality the hope and expectation of the government that India itself may one day be an arbitration hub. But I must say, ladies and gentlemen, that there is an air of expectancy wafting through arbitration circles in India. After a long time, ladies and gentlemen, it appears that the reforms to the arbitration ecosystem in the country is backed by solid political will. And ladies and gentlemen, if one were to look beyond the many contradictions and challenges of India, one cannot but be optimistic about the future of arbitration in India. Ladies and gentlemen, on that note, thank you very much for your kind attention, and also to the organizers, CNICA and the Telangana Chambers of Commerce and Industry, for your very kind invitation. if there are any questions, ladies and gentlemen, I'll be very, very happy to take it up during the question and answer session. So the three Murtis, Anand, Saravanan, and Ashokapati, I hand the floor back to you. Thank you once again.
That's excellent topic, Ajay. I just recollect, Ajay, if you can stop sharing. Yeah, fine, thank you. I still recollect the day when we were talking about what topic to talk about. And you came up with a couple of them, and this was suggested. And I knew that you were going to give a good topic and good address. I knew that, and I've been seeing you for a long time now that you give excellent address. But this was not expected. It was too good, and you nailed every other point. It was just not optimism. It was a calculated, taking things forward and in a systematic manner. You were not giving a hope here and there, but you were categorically stating what are the route map to achieve it. We at CNICA also acknowledge the fact that this is the time for us also to put in all our efforts. We are having our belts tightened. We are proceeding with it. We are taking all necessary initiative to be one of the foremost institutions. Sure, we will see that KK Venugopal is honored by what he had said, the other way around rather. Okay, before going to the questions, I thought I will make these things, what I had in my mind, I wanted to tell. And now let's, there are lots and lots of appreciations for you. And in fact, one of the person has said you are going to be the future Nani, Fali. And I think that's going to make you very happy also. Now, there are a few questions from our institution itself. The first one from Saravanan is, will allowing of foreign lawyers to practice in India make India as an arbitration hub?
Well, my short answer to that would be that it would, solely by itself, it is not going to do anything, but in conjunction with the other ingredients that I adverted to in my speech, that would definitely result in the country emerging as a more arbitration-friendly jurisdiction, as an arbitration hub. Look at all the jurisdictions in the world which are arbitration hubs. Look at the example of Singapore. Look at the example of Hong Kong. Look at the example of the UK, New York. Look at Paris. Look at Geneva. All these jurisdictions which are leading arbitration hubs, parties have the freedom of choice of counsel. So I honestly believe when there is a German company investing in India, and if the German company is persuaded to have a seat of arbitration in India, then it would be imperative to give the comfort factor to the German company that they can have the services of their German lawyers to support them in the arbitration process. And that's the rule, and that's the norm when you're looking at all leading arbitral institutions and all leading arbitration jurisdictions in the world. So I honestly believe that would be a very, very important ingredient in that larger mix of ingredients which go to constitute an arbitration hub.
Mr. Abhay Kumar Jain, it's almost a statement, but what I can derive from that is, he feels that it is high time that arbitration bar is a full-fledged bar rather than being a part-time bar. A lot of people advocates practice arbitration as a part-time activity. Instead of that, he feels, should it not be made as a full-time aspect?
Well, should it not be a full-time, but then to a large extent now this is more of a self-regulating thing, right? So nowhere in the world do you have a formal arbitration bar as such by which lawyers practicing in other areas of the law are barred from appearing in arbitrations. Yes, it would be highly desirable for practitioners to be focusing only on arbitration, but we must realize that focusing on arbitration to a large extent is a voluntary process. It has to be a voluntary process, and it also has, to a large extent, depends on the practices, the law practices which have been developed by individual legal practitioners and law firms. So I'm not too sure whether it might be the way forward in regulating and establishing a formalized arbitration bar, but I honestly believe it will have to be a voluntary arbitration bar. And there is, and as I said in my speech, there is a recent initiative to constitute such a voluntary arbitration bar, and that is called the Indian Arbitration Forum, IAF. And to a large extent, this forum has been constituted comprising of lawyers and arbitrators based around the length and breadth of the country. And this comprises of people whose focus to a large extent has been on arbitration. So yes, whilst it might be very difficult to constitute a formalized arbitration bar, there exists today a voluntary arbitration bar which is called the Indian Arbitration Forum. So you might want to check out the website of the IAF or the Indian Arbitration Forum to understand what this group of individuals does and how it is trying to create an informal arbitration bar in the country.
Yeah. The next question is a corollary to the first question asked by Saronan. What will be the disadvantage to Indian lawyers if foreign lawyers are allowed to practice in India?
Well, we must remember, foreign lawyers who would come to India will not come to the Madras High Court or the Guindy Sessions Court to practice. Foreign lawyers are only going to be looking at the meaty work. They are going to be looking at high value commercial disputes, high value transactions. So that fear which is there amongst Indian lawyers, that opening up the legal services sector to foreign lawyers will affect the fortunes of Indian lawyers, I think is a myth. Though yes, the jurisdiction or the people who will be affected the most would be the large Indian law firms, because the foreign law firms who probably will, when they come and practice the law in India, they would be looking at the meaty international arbitration work. They would be looking at the meaty commercial arbitration work, transactions running into millions in dollars. They would not be interested in the small value disputes before the High Court or the district courts or before the magistrates courts. They would not be looking at low value commercial arbitrations. They would be looking at a particular aspect of that market, and they would be looking at the stratospheric heights of that market. So I think any fears which an individual lawyer would have should be rested that opening up of the legal services sector, I don't think is going to affect the bread and butter of probably 90% or 95% of Indian lawyers. But we must remember, having said that, we must remember that opening up of the legal services sector is very important if the jurisdiction aspires to be an arbitration hub. But again, as I said in my speech, it is a slightly controversial and a touchy topic as to whether India should open up its legal services sector. So it's a call which the government has to take. It is a call which the government has to take as to what do you want to prioritize. Do you want to prioritize the positioning of India being an internationally accepted arbitration hub, which in turn would allow greater flow of foreign investment into the country? Or do you want to be looking at the interests of that 10% to 5% constituency of lawyers who might be affected by the opening up of the legal services sector? But having said that, I will hasten to add, ladies and gentlemen, that my view is that the legal services sector will have to be opened up, if India aspires to be an international arbitration hub. But that opening up of the legal services sector will have to be done in a gradual manner. It will have to be done in a phased manner. I am not advocating the opening up of the legal services sector all of a sudden to foreign law firms in all aspects of the law. It has to be opened up in a gradual manner. It has to be opened up to certain sectors of the legal profession. That's my view on the opening up of the legal services sector.
Yes. The next question is again from Saranan. He says, his question is, in the recent times, we have seen that arbitration proceedings also involves a lot of technicalities and procedurals like that of civil procedure code. Is it a healthy trend when India aspires to be an arbitration hub? Yeah.
Sarvanan, I lost you in between. I gather your question.
You want me to repeat the question, Ajay?
Yes, please.
Yeah. In the recent times, the arbitration proceedings have started involving a lot of procedural and technical aspects like that of civil procedure. Is it a healthy trend when India aspires to be an international arbitration hub?
The short answer is no. And I think this is where existing arbitration institutions like CNICA would and can play a very important role in introducing international good practices into the Indian arbitration ecosystem. Getting the technicalities of CPC into the arbitration procedure is definitely a retrograde step. It is definitely not internationally accepted best practice. So I think this is where I think there's a big responsibility upon CNICA also to be conducting training and education of existing lawyers who service arbitrations in India to evolve from being CPC lawyers to being more, international, to be more in tune with internationally accepted arbitration practices. In my view, ladies and gentlemen, I have a very golden rule when it comes to the relationship of CPC and arbitration. In my view, when you have an arbitration clause, the CPC goes out of the window. I'm sorry for being very direct. In my view, when you have an arbitration clause, the sum and substance and the effect of that is that the CPC should go out of the window. And I think this is something which is, this is a message where I think there's a big responsibility on existing arbitral institutions to educate the general rung of arbitrators and lawyers. And I think that's the way forward. If at all we aspire to be a leading arbitration hub, ladies and gentlemen, I didn't talk about that. Education is a very, very important factor. And I think that is where, there's a big responsibility on institutions.
Yeah, exactly. Now that is where you are also now in the education sector, also trying to give in more advocates, law schools, students in arbitration practice. I presume. Anand has got a question. He is asking. I'll read out the entire question. Certainty, predictability, and stability is the essential bedrock of an arbitration hub. It has to be recognized that India is has a very large jurisdiction with 25 high courts and over 600 high court judges and over 30 Supreme Court judges. And indeed, the spectrum of judicial delay. Would it be realistic to expect a uniform and consistent judicial approach or outcome? Can India ever become an arbitration hub if this is going to be the case?
Again, I think I have a very short answer to that. There is a body called the National Judicial Academy based in Bhopal. When a person becomes a high court judge, or he is sent for training, a short refresher course to the National Judicial Academy. The National Judicial Academy functions under the aegis of the Supreme Court and the Chief Justice of India. It conducts refresher courses periodically for all High Court judges, also for Supreme Court judges, and also for judges from the subordinate judiciary. So here is an organization through which you can actually introduce a certain sense of uniform in terms of understanding about the basic interpretation relating to the provisions of the Arbitration Act. So uniformity amongst courts can be introduced basically by the efforts of the National Judicial Academy, by the judicial training academies, not only the national level, but by the state judicial academies. Every state, we must remember, has a state judicial academy. And this is again, I believe, where existing arbitral institutions can play a role in sensitizing the judiciary in their respective jurisdictions to be more arbitration friendly. When I mean arbitration friendly, I would not want the judiciary to be blindly in its friendliness towards arbitration. It has to take a pragmatic approach, a realistic approach towards arbitration. And this requires training, it requires sensitization. And again, I think there's a big responsibility on institutions and institutions to work together with the National Judicial Academy, institutions to work together with the State Judicial Academy. So nothing's going to happen overnight, ladies and gentlemen. It's a process. The journey of 1,000 miles starts with a single step. We have embarked on that journey. We have taken not one step, I would say we have taken hundreds of steps towards that journey. We have covered a few miles, but we've got many more miles to cover in that long journey. And that again, ladies and gentlemen, sorry to be putting speaker in the spot of bother, but again, it's a big responsibility on institutions to be reaching out to the judiciary through the judicial training academies in sensitizing the judiciary to international best practices.
Yes, again, reiterate, we do understand our responsibilities. We are proceeding towards that end. I think we are running short of time also, so I'll cut short a couple of questions. And one question of Mr. JNL Murthy, who said you are going to be following Fali. His question is, Professor, what needs to be done on human resources arbitration development? That's his question.
Human resource and arbitration development, I believe, so there's an old saying which says that your arbitration is only as good as your arbitrator. So human resource development and arbitration is extremely important. If you want to have good arbitrations, you need good arbitrators. If you want good arbitrators, you need arbitrators to be trained. If you need discipline in the process of arbitration, you need lawyers who are sensitized to how arbitration processes are conducted. You need lawyers to realize that arbitration is different from court proceedings conducted under the Code of Civil Procedure. And all of this, training plays a very, very important role, plays an extremely important role. And my view is that, again, institutions may not be in a position to control what the judiciary does. Institutions might not be in a position always to lobby with the government and get changes to legislation. But institutions can definitely work in creating an ecosystem where international best practices, internationally accepted training modules are rolled out for arbitrators and arbitration lawyers in India.
Thank you so much, Ajay. Now may I call upon Mr. Abhay Kumar Jain of Telangana Federation for Telangana Chamber of Commerce Industry to render the vote of thanks. Mr. Abhay, you can unmute yourself.
Yeah. It's my privilege to hold the vote of thanks on behalf of CNICA and FITCI for today's topic, session talk on India's hub of international arbitration it's an idea whose time has come. First of all, I want to thank today's Professor Ajay Thomas for his excellent enlightenment and inspiring speech. And what I understand, very passionate about becoming India as a hub for international arbitration, which has been non-continuously he spoke with such a passion. So, thank you for total overview and information about the jurisprudence of international arbitration, such stories of international arbitration in Hong Kong, and going through the ingredients of any ingredients to international arbitration of Indian system and how it can become is what is to be adopted. Arbitration. That's very clearly and very lucid manner. He has also told about his talk about the judicial trends in Indian judicial system. Where are the pitfalls there? He has also told what judicial reforms has been taken by India towards the step of international arbitration. Yes, touched so many aspects that this topic of his more than 40 years, I can say, in his. So, and today participants, we can through chat we can understand that so much participants were having so much messages for him. I want to thank ISA's chairman D. Sharavan and D. Secretary D. Anand and Treasurer D. Ashok for organizing this program and making FITCI as a joint organizer. Last but not least, today's participants were hearing for their appreciation and for their coming. I thank them and I invite them to all coming, which we are going to do every week or fortnightly. So, which I end my vote of thanks. Thank you.
Thank you, Mr. Avikumar. But for the small technical flaw, it was a good summation of what Ajay had spoken. Thank you one and all. And with this, we end the session.